All right, we are back. It is our final segment this morning. Chris Johnson, Takacs, McGinnis, elder law, questions about estate planning in terms of legal issues that you may have coming up. We've talked about power of attorney. We've talked about wills. We've talked about the fact, Chris, that the vast majority of Americans, or I don't know, vast majority, but you said most do not address these issues until it is too late or until a crisis comes along. And it's just not worth waiting. You may not need it now, and it may seem like a drag going out to do it. But if you wait until there's a real crisis, that's just another layer of headache.
It really is, and it's a layer of headache, and for a lot of people, even worse, it's a layer of expense because when you don't have the proper prior planning taken care of, and then these emergent situations arise, the cost to fix them goes up astronomically. And it's one of those things that I always emphasize: when it's done, it's done. Now, it might not be done forever, but boy, it's done for the next 5, 10, 15, 20 years. I had someone come in and we reviewed their documents. I think their documents were 15 or 20 years old, and they were said, hey, we just haven't looked at them in a while. We want to go through them. And I did a document review with them, and I reviewed the key players. I reviewed a lot of the key provisions, and I looked at them and I said, these are still good. You don't need to do anything. You don't need us on this. As long as these decisions stay the same and you're comfortable with this planning, you are in a great spot. And you could see the look of the relief. It felt so good, and it was worth just coming in for that peace of mind. That's the real intangible that people leave out in this, is when you have it done, we have enough stuff to worry about these days. I mean, pandemics and you know, people fighting and everything else. It's like, listen, let's take one less burden off of you, and getting that estate planning done and knowing that if something tragic were to strike, you and your family are prepared. And you can't really put a dollar amount. It kind of sounds cliche to say that, but you can't put a dollar amount on that. And I'm always satisfied at my clients to see how relieved they are. We've signed all those documents. We've executed everything. They know kind of the last steps to take care of, and they feel like we have put this off. I've lost count, Nick, and the number of times I've heard, Chris, we've put this off way too long. We're so relieved to have it, and it feels good to be a part of that.
Hey, and remind folks this one thing. It's a good civics lesson that you can lay out. Again, when you don't address these things and it's laid out there without any legal protection for you or your loved ones, with power of attorney and the like, probate court is sometimes where it ends up. Can you please, and I kind of know it, but even if you asked me the same question, I know I couldn't do it as well, anywhere as well as you are going to be able to. What is probate court? When does it come into play? And why is that something you want to avoid if you can?
Yeah, probate court, it's this kind of big mystery to people. And remember, you know, it can be, you know, oftentimes we don't hear the ordinary, we only hear the extraordinary. And you'll hear people who had a terrible experience with probate, and they'll tell everyone, oh, it was awful, it was miserable. No one's like, well, we went through probate and it was fine. And the thing is, there are lots of people who went through probate. It was fine. It wasn't that big a deal. The nice part about avoiding it, I always tell people there are 3 things. So probate is the orderly distribution of your assets after your passing if you haven't set up alternative options, alternative routes for them to go. So probate deals with probatable assets. So your bank accounts, possibly your home, all these big ticket items. You know, if I pass away and I have a checking account that's got $100,000, the bank just can't rely on people showing up and saying, hey, Chris told me he wanted me to have this account, you know, can you please turn it over to me? The banks they would have trouble very fast. So we've set up this orderly thing. And so probate literally comes from the Latin term probatum, which means to prove the thing, because step 1 of probate is you bring the will and you prove the legal validity of the will, if there's a will, or you say there is no will. Once the courts accepted the will or accepted the fact that there is no will, everything else is just administration. It's just following the terms of the will and following the statutory requirements of probate. And here's where it gets tricky. The 3 things that I tell people that it's nice and convenient to avoid probate is first is time. It'll take you getting into the attorney's office, getting documents drafted, getting them submitted to the court and filed, and then getting on the court's docket. You're looking at probably a minimum of a 2-month period right there. Then if everything goes smoothly and they issue letters testamentary to the personal representatives who's going to be, or executors, I think more people probably commonly understand it to be named, then you're going to have a 4-month creditor window. And so you basically have to wait for 4 months and let any possible creditors make their claims. You have to provide notice to all of them. And then once that creditor window closes, then you wrap up administration. And so the first thing is, it just is a lengthy process. If everything goes right, you're looking at 6 or 7 months. And if things don't go right or people are contesting things, it can drag on a significant amount of time. And then the second thing is cost. There's a cost of entry. The court fees, they're nothing oppressive, but there are court fees. But more expensive is the attorney's fees. And if you can avoid having to pay attorney's fees, certainly avoid paying. And so doing a revocable living trust plan where you avoid the probate process, well, there's no attorney's fees there because you can wrap everything up kind of on your own privately. And that brings me to the third point. And this is the point that really hammers home with a lot of people why they want to avoid probate. Probate is a public record. When you file a petition to open probate, it is a public record, which you have to list the name and address of all the heirs, and you have to list an estimated value of the estate. Well, the estimated value of the estate, your net worth, that's nobody's business. And frankly, who's getting what is also nobody's business, because these heirs, now you're kind of painting a target on their back. We talked about these scams, the grandchild scam, grandparent scam. There's all sorts of other scams. Check your junk folder or spam email folder. Every day, people are trying to scam you. You don't need to give them directions on how to get to their front door, because this person is basically a potential lottery winner. And that privacy aspect, that really resonates with a lot of people, especially in today's day and age where there's so much information at our fingertips. Technology empowers so many people. The problem is, not only does it empower the good actors, but it very much empowers the bad actors. And so being able to sidestep the probate process when you don't need it. And that's really the key. Some people will want to go through probate. I had one client, I went through probate avoidance, and they said, Chris, you know what? I just feel more comfortable with a judge kind of keeping an eye on the whole process. And I was like, that's fantastic. We can absolutely make that happen. And that's what gave them peace of mind. And so probate, and whether you go with a will or whether you go with a trust, I always tell people they're like tools in a toolbox. And the goal is, are we bringing the right tool to the right job? And that very much depends on your clients, what their wishes are, what their goals are, and making sure that, again, you're starting with the end in mind and trying to provide that proverbial peace of mind.
Listen, as we wrap things up, Chris, I want to remind folks, if you can, where you guys are located, how you can go about getting an initial consultation. It doesn't cost anything really to get it checked out. And of course, the fees that you and your colleagues charge over there, it depends on the size of an estate, I imagine, and the tasks at hand. But I mean, you don't have to have a ton of money to get some of these basic things worked out. So remind folks where you're at and how you can set up an appointment and get a sense of maybe whether it's something you can even afford to do.
Yeah, absolutely. So we're located in Hendersonville, Tennessee, right off Veterans Bypass. Our phone number is 615-824-2571. And if you just call in, you'll speak to one of our intake people and tell them what you're looking at. And generally, we charge on what needs to be done. That's really the key aspect. We take a look at what your personal situation is, what tailoring a specific plan to you is, what we need to get done, and then we'll quote you a price for that at the time. We do consults. They generally go for $350 for an initial consult. We walk through. If you go forward, we essentially waive that consult fee and just quote you what the fee will be for the work. But the key is call, ask, go through the consult. There really is is no such thing as an estate too small. You know, if you're still just starting out, just having that legal and financial and healthcare decision making, that is one of the most crucial aspects of any solid estate plan, are those healthcare and durable general powers of attorney. Getting those in place is critical, and then tailoring the rest on what your needs are, and more importantly, what your goals are. Because at the end of the day, we want to put together a plan that accomplishes what you want it to accomplish.
And that can be done over just a period of days. It doesn't have to be that long. You have a few meetings, you lay it out how it is.
Right.
And then once it's set in stone pretty much, unless you want to make changes, you're done.
Yeah, you're all set until you really want to tweak it or make some changes. Like I said, that plan is going to be good for hopefully many, many years. And that's where that redundancy comes in,
right,
and drafting this stuff, forward thinking and going, okay, if this goes wrong, if that goes wrong, do we have those contingencies built in so they don't have to run back to the attorney's office with every little contingency? We've taken care of that in the draft, and it's very critical because we want them to stand the test of time.
Exactly. Hey, Chris, listen, thank you for coming on. You are a very good guest. You're a chatty guest. And today we didn't get a ton of calls because we're back live for the first time in a while. And it's wonderful that you share that much info for us. And it's just a really good program. Thank you. I hope people take note. When we come back, I'll make sure to put up the contact information for you guys at Takacs and McGinnis so they know how to reach out to you guys. And listen, take care of yourself. We'll talk to you again soon, all right?
Thank you so much,
Thanks,
Nick.
my
Always
friend.
a pleasure.
All right, that's Chris Johnson. We'll take a break. Be back with a programming note and his contact information right after this.